Thank you. Thank you. Please be seated. Good morning. Again. All right. Mr. Heath, are you ready?
Morning, Judge. My client is running late.
Okay. Let me know when you're ready.
For a bit. Yes, sir.
Well, this is the one that I was most likely to not spill.
Good morning, Ms. Condi. Ms. Condi, can you hear me? Maybe not. Okay. Ms. Condi, good morning.
Good morning, Your Honor.
Ms. Condi, your client's name is Connor Pratt, correct?
Sure. Thank you so much for hearing this motion. The motion to return property that I filed for Pratt. Essentially, when he was arrested, there were items that were taken from him. He is on the he's got very soon. I know he's getting instructed today by probation. He made the trip out there for a lot of appointment with probation. But I believe that the state has no objection. I did speak to Mr. Gomez about an objection to the property being returned from the sheriff's office, and he indicated it could be done.
To the state?
Judge, Sarah Berkman for Mr. Gomez this morning. If we could just leave the PTI with the on the docket with the understanding it'll fall off. I believe he has been instructed and completed the intake. I don't see any notes currently as far as property return, but I will ask Mr. Gomez and have him send you an email.
Okay, because the motion says the state has no objection to it, and that was filed on the 14th.
Perhaps we could...
I had emailed me back saying that there's no objection, but I don't know if the prosecutor has the email.
If we could just pass him for a moment, I will ask.
Okay, Ms. Condi, do you want to hold tight? Okay, thank you. Is Donovan Newsom present?
He is, Judge.
Mr. Newsom, come on to the lectern, if you will, please, sir. It's 22 CF 3008. Hello, Mr. Newsom.
Good morning, Your
Good
Honor.
morning. Mr. Newsom, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I just got a new job. I make like $13.50 an hour. I don't really know, sir.
Okay, how long have you been working? Were you working before that job?
Yes, sir.
How much did you average making per month?
I'd probably say like up to maybe 1,000.
Okay, I do appoint the public defender to represent you. Mr. Koch is coming on your left.
Good morning, Judge.
Good morning, sir.
Thomas Koch, just filling in for Mr. Scott Kleins. Just being appointed, Your Honor, we'll enter a denial.
Okay. Set it for the next miscellaneous date.
Yes.
So November 16th at 9 o'clock. So, Mr. Newsom, your homework between now and then is stay in touch with, it'll be Mr. Kleins will be your attorney. He's at the public defender's office.
Yes.
They'll give you his card, make an appointment with him, attend that appointment, whether it's live or by telephone, and then I'll see you back here on November 16th at 9 o'clock. Okay?
Yes, Your Honor.
Thank you, sir.
Thank you.
Yes, sir. Mr. Newsom, is that your mom with you?
Yes.
Good. Thank you so much. Thanks for being here, ma'am. Marjorie Vaughn. Hello, Miss Vaughn. If you'll please come to the lectern. 22 CF 77. Does the state have an offer for Miss Vaughn?
One second, Your Honor.
So, and the reason why I ask is if they are offering you something that you're interested in taking without the appointment of an attorney, then we'll talk about that, okay?
Yes, sir.
Probation? Yes, ma'am.
Your Honor, she has completed 27 hours of her community service. She has 23 hours left. She wanted to ask in court today if she's allowed to pay off that 23 hours, and if she is, she has the money now, and she can go down to the clerk and pay it right now. And then the officer said they'd like to dismiss and terminate.
Okay. Any objection from the state?
No, Your Honor, that would be our recommendation as well.
Okay, thank you. So, Ms. Vaughn, I do allow you to pay off those 23 hours.
Yes, sir.
You're going to do it today?
Yes, sir. I'll
Okay.
do it right now if it's going to be in the computer.
Yes, ma'am. Upon you doing that, then the case will be dismissed. Just for my purposes, where it totally doesn't fall off everybody's radar, I'm just going to set it for a status conference on November 16th at 9 o'clock. If you pay that off and your probation is terminated, then you don't have to come, okay?
Yes, sir. Thank
Thank
you
you,
so
ma'am.
much.
No, sir, it's paid directly to the clerk. We just needed the judge to say it was a court order.
Okay. So how's the clerk going to know that downstairs to take it? Madam Clerk? Okay. Is November 16th at 9. Okay. So when you go downstairs...
Yes, sir.
Or, I'm sorry, just down the hall, you may want to wait just a few minutes and tell them to check the email from the clerk that's in the courtroom.
Yes, sir.
And check those minutes.
Thank you so
Okay.
much, sir. I
Thank you, ma'am.
appreciate it. Thank you.
Thank you, probation. Okay, the rest of the defendants, I think, are represented other than Mr. Cobb, who's not present. Yes, sir, to the PD, the folks in the gallery, do you want to take them first?
Mr. Cecil Rowell.
Mr. O'Rowell.
Jason McKinney, on behalf of Mr. Rowell. He is here in 22 CF 585. He's previously been found incompetent to proceed. He's doing competency training with APD and Mr. Sanchez.
Yes, sir.
Mr. Sanchez and I have been in communications, and he did provide a status letter to the court. In that status letter, he indicated that it would be appropriate for the court to sign an order to appoint another expert to reevaluate Mr. Rowell, given that it is past ripe for the last evaluation, and that he is, in Mr. Sanchez's opinion, currently still incompetent to proceed.
I did see that in the report. Any objection from the state?
No, Your Honor.
Okay. In the letter or the report, it says the defendant has made no significant gains in attaining competency, and it is this
Liaison?
is that what it is? But it was
Yes.
with a capital L, and so I was wondering about that.
Yes.
Liaison's recommendation that the defendant be reevaluated to get an opinion on restorability now that he has participated in the competency training. So I do appoint a second evaluator. So, Mr. Rowell, another doctor will come and talk to you, and then do you think November 16th will be enough time, or should we do December 11th?
I think a December date would be appropriate.
Okay,
And may I add Dr. McDonald as the evaluator?
that'd be great. Yes, sir.
Yes,
So
sir. I'll
Dr.
provide that
McDonald-
order to the court.
December 11th at 9 o'clock. Okay. Mr. Rowell, I'll see you then. You look like you lost weight, Mr. Rowell.
Trying to.
Okay. Thank you, sir.
Take care.
You too.
I believe that's all I have in the gallery.
Okay. Mr. Koch, any folks in the gallery?
I don't believe so, Your Honor, and I am covered for Mr. Klein this morning, so I don't believe...
Okay. Any other defendants that are in the gallery? Okay. Yes, ma'am. Come on up. You'll come to the lectern? Thank you.
Cassie Moore.
Thanks, Miss Moore. Okay. Thank you. Yes, ma'am. 20 CF 1000.
And I apologize, yes, I'm just looking at
Certainly.
Mr. Klein's notes. Is there an offer from the state to Ms. Moore? It looks like she has completed public service, community service hours. Do you have any outstanding? Any more you have to do? Or do you have to
To the state regarding Ms. Moore?
Just a minute.
Judge, my understanding, the offer from Mr. Gomez is in exchange for admission to the violation, the offer would be 6 months county jail with credit for time served.
May I ask probation, are there any outstanding requirements?
What her officer said is that she completed parenting class and some of her community service hours. Does she have them all?
Is that the only things that was outstanding?
Your Honor, she has an outstanding balance of $1,363.20.
Is the financials that are left?
The only thing else I see on here is comply with DCF. Has she done that?
That's been closed for 2 years now.
Yes, ma'am.
Judge, if that changes the state's offer, well, then we may be able to resolve this today. Otherwise, we'd be entering a denial.
Ms. Davis, $1,363.20.
Judge, at this point, I would say we set it for 11/16 and see if she can get that amount paid off, if that's enough time for her.
Okay. Ms. Moore, do you think you'll be able to pay it off?
I can try.
Okay. Do you want to set it for December 11th?
That's fine.
Okay.
Yes, Judge.
So December 11th at 9 o'clock, I'll see you here then, okay?
Okay,
Thank you, ma'am.
thank you.
Make an effort towards paying that off.
On Ms. Conti's client,
Next is Heather Rogers with Mr. Cox.
okay, hold on one second. On Pratt, any update on that to the state? To hear back?
Your Honor, it appears that the return of items were just a phone and I believe some other electronics. So at this point, we would have no objection to return the property.
Okay, good. Ms. Pratt, then your motion is granted. I'm sorry, Ms. Conti, your motion is granted. Okay?
Hey, George.
If you'll get me a proposed order.
Send an order to your office?
Yes, ma'am. If you'll email it to my JA, that'd be great.
I will do that today. Thank you so much.
Thank you, ma'am.
I have one today.
Yes, ma'am, you too.
And Your Honor, I don't have any further business if I could be excused.
Yes, ma'am, thank you.
Thank you.
Okay, now Mike?
Heather Rogers with Mr. Cox.
Okay, thank you.
Thank you. Yes, Judge, this is Ms. Rogers to my right, Your Honor. We're here for this morning for 22 CF 2237, and she is placed on the afternoon docket, and that's in 23 CF 2123, Your Honor. And
Yes, sir.
we'll be entering a denial for the violation of probation, and a not guilty will be entered for the grand theft charge. And
Okay.
waive formal readings, Your Honor.
Okay. So we want to set it for the November 13th pretrial, both cases?
Yes, Judge.
Okay. Ms. Rogers, I'll see you back here on November 13th at 9 o'clock. If the state offers you something that you want to accept before that date, Mr. Koch can set it for a hearing before then. On November 13th, we'll probably have 200 or 300 people here, okay? Yes, ma'am. Thank you. Thank you. Mr. Heath, let me know when your client's here, okay?
I will, Judge. He's on the way. I've been keeping tabs on him.
Thank you.
Judge, may I just have a brief moment?
Yes, sir.
Gotcha. Thank you. Good morning, Mr. Bourne.
Good morning, Ms. McMullen.
Yes. Yes, Your Honor. Thomas Koch, covering for Mr. Kleins. This will be a change of plea, Your Honor. And it'll be a no contest plea entered as charged, Judge. Be 2 years probation, 24 hours community service, the substance abuse evaluation with any recommended treatment. There's $616 in court costs, $150 for the public defender fees, and it does state that defendant is authorized to travel to Georgia on the dates from November 2nd to November 4th, Your Honor.
Okay, and then there's $40 per month cost of supervision.
Yes, Judge.
And as part of the probation, she'd have to submit to random UAs, correct?
Correct, Judge.
Okay,
And I'm just having the state just sign that free form.
thank you. Ms. McMullen, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. So, Ms. McMullen, let me start with what I just stated verbally. Do you understand that in addition to what's maybe in the writing, that you'll have to pay $40 per month cost of supervision?
Yes, sir.
Okay. You also will need to submit to random urinalysis. Do you understand that?
Yes, sir.
Okay. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. McMullen, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You'll need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, and the court has no objection to you traveling to Georgia from November 2nd through November, is that 4? Through November 4th.
Yes, Judge.
Yes, sir. I can make it. It's my son's senior day, so I was just trying to make sure I had enough time to get there. Okay.
Okay. Thank you, Ms. McMullen.
Judge, if we can call her at the end of the docket.
Okay, fine with me. Rachel, can we call her at the end?
Yeah, he's got a bunch of meetings today, so he wanted me to text.
Oh, Rachel, you've got the docket other than that. Who do you want to call next?
We're going to do Bruce Lockett next.
Okay, hold on 1 second. We've got Mr. Heath's client. Mr. Heath?
Ready, Judge?
Yes, sir.
Sorry.
Ready.
Good morning, Your Honor, and thank you for the court's patience. James Heath on behalf of Clayton Reddick Blackshear.
Yes, sir.
That's going to be case number 21 CF 2409, 20 CF 2405, 20 CF 1954. Your Honor, to remind the court, this is the continuation of the sentencing hearing where the state, Mr. Gomez and I, and the court had to have a conversation about the colloquy versus the sentencing, and et cetera, et cetera. We have everything squared away, and Ms. Davis is going to make some announcements, again, pursuant to housekeeping. We have to, in between the day that we were here last time and now, there were some things that should have been done, and we're going to correct them orally. And I'm speaking for the state right now, but we've already talked about it. She'll explain more clearly to help your clerk get this squared away is how to reflect the proper reflect the proper charges for the documentation, Your Honor.
Good. Okay. Yes, ma'am.
There were 2 battery charges, Leo and an aggravated battery. Both of those, in exchange for the plea, we're agreeing to a lesser included of a resisting with violence, Judge.
Okay. Do you have the statute number for Madam Clerk?
I will.
Okay. If you'll provide those to the clerk. As far as housekeeping, I also had a note that said, was Mr. Blackshear ever found to be competent to proceed? Because wasn't there there was an evaluation or at least something that was raised during the case?
No, there wasn't.
Dr. McDonald, right?
No, there was a judge. I'm not sure why that note would have been in there. Mr. Blackshear's been squared away from the get-go as far as those issues are concerned.
Because it's a different Mr. Blackshear. Okay, good. Thank you.
It's 843.01.
Mr. Blackshear, what's your date of birth?
13 March 83, Your Honor.
Okay, thank you. There was a different Blackshear that was stuck in with your file, and okay. Mr. Blackshear, you're adjudicated guilty. You're sentenced to 60 months with the Department of Corrections with credit for all time served, and that's to run concurrently on each case and count, other than the misdemeanors or time served.
Judge, on the DUI, on that misdemeanor count in 21 CF 2409, we asked that the minimum DUI requirements be assessed for that case, but we D6 all the requirements, but I think the fine, we're going to go ahead and impose that at this point.
It would be the court cost plus the $500 fine and the surcharge.
Right. Okay. Yes, ma'am, that's granted. So you'll need to pay the court cost. That's times 2. The $100, let me make sure I'm reading it right. The drug offense, $525, the $100 FDLE fee, the DUI court cost, $438, the $500 DUI fee plus the 5% surcharge, and the $50,000 fine plus the 5% surcharge. So all of those amounts will go to a civil lien or judgment. Mr. Blackshear, you do have 30 days to appeal this judgment and decision. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do.
Mr. Blackshear, you were a little late this morning.
I apologize.
But I can't imagine how tough it is to come for the sentencing today. So I appreciate that. That helps the court for future defendants that want to defer their sentencing. So thank you, sir.
I apologize for wasting any time.
One last thing, Judge.
Yes,
I
sir.
haven't done this over in Okaloosa. I've done it in other circuits. Can the court recommend or suggest a CI? I know you can't order one, but we would respectfully request that the court recommend a CI for his housing.
Tell me what that is.
Bay Correctional Institution, the location for the prison.
I'd certainly request for Mr. Blackshear to be housed closer to Okaloosa County or in Okaloosa County if possible, because I think that it's better for you, it's also better for society. So I do ask that.
Thank you, Judge.
Yes, sir. Thank you.
Your Honor, that's all I have before the court this morning. May I be excused?
Yes, sir. Thank you, Mr.
Judge.
Heath. Thank you.
Judge, this is Bruce Lockett before the court,
Yes, sir.
and I'm standing in for Mr. Kleins today. Mr. Kleins represents Mr. Lockett in 23 CF 2132, and a felony violation of probation, which is 22 CF 2773. And I believe that Mr. Kleins has already entered a denial and a not guilty plea in the 23 CF 2132. So if we could schedule both for the 11/13 pretrial to run together, I believe that would be appropriate.
Mr. Lockett, I'll see you on November 13th on both of your cases, okay? Thank you, sir.
Judge, this is Mr. Moser before the court. Judge, hold on. Judge, Mr. Moser is here in two case numbers, and he's represented by Mr. Kleins. He's here in a felony violation of probation, 23 CF 1242, and a new law. He's on the arraignment docket in 23 CF 2120. I believe that Mr. Kleins has entered a not guilty plea in the new case and entered a denial in the violation of probation, and we'd like for both of these to track together on the pretrial on 11/13.
Okay. Mr. Moser, I'll see you back here on November 13th, okay? Yes, sir. Thank you, sir. Thank you. Oh, Mr. Patterson. Good morning, sir.
Yes, Judge. For this morning docket, we are scheduled for sentencing.
Yes, sir.
In case numbers 23 CF 93 and 23 CF 1849. Last time we were in court, we submitted the plea form signed by my client.
Yes, sir. And I've got that. Is there some other case?
Judge, on the 8th of October, my client picked up a new law while he was out for battery, and I believe that is on the 130 docket for the new law.
Do you want to do the arraignment for that now, or do you want him to come back at 1:30?
We could do that now, Judge.
Okay, please.
We'll enter not guilty on that charge.
Okay. Sure.
That's right.
Okay, good. Okay.
So it's a misdemeanor battery, Judge, so I apologize. It's only for sentencing in front of this court.
Okay. So once I sentence Mr. Patterson to prison, then I lose jurisdiction. Are they going to transfer him immediately, or is he going to be able to do the misdemeanor before he leaves?
Judge, of course, the new law was a bump in the road. It wasn't planned. I don't know I believe if we enter or the sentencing today, he will still be held for the misdemeanor.
Okay, good. Mr. Patterson, in accordance with your plea agreement, you're adjudicated guilty. You're sentenced to 15.45 months with the Department of Corrections with credit for all time served, and that is to run concurrently. You'll need to pay the court cost of $1,482, the public defender fee of $250. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 90 days from today. You'll also have no contact with Robert, is it Auger, A-U-G-E-R?
Yes, Judge.
With Robert Auger. Mr. Patterson, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir. I got a question.
Yes, sir.
Okay. Okay, I got out.
Well, what's your question?
I need that long day to get my sheet. I'll remove my sheet when I get. Please. Should I be done with them? Should I? Okay.
So, Mr. Patterson, if they hold you for the misdemeanor, then they'll hold you for that. Otherwise, they'll take you to the prison. Okay?
Straight to the police.
Collections. Yes, ma'am. Civil lien or judgment, please. I don't think you. Oh, let's see if I got a score sheet. I don't have a. To the state, you'll provide me with a score sheet for Mr. Patterson?
Yes, Your Honor.
Thank you.
And Judge, to the state, if the court be willing to entertain jurisdiction, if we stipulate to it for the misdemeanor case, is the state in a position to make an offer?
The state is in a position to make an offer, and the state would make an offer for credit for time served and court costs.
And Judge, I've discussed that with Mr. Patterson standing here, and he wishes to proceed forward, given that he is sentenced to the Department of Corrections.
Okay. What is that case number?
That case number would be 23MM3682, Your Honor.
Mr. Patterson, very strange, because usually once I sentence somebody to prison, I lose jurisdiction at least of that case, and I think I do. But now I'm changing hats and I'm sitting in for a county judge. And so if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand out. So in the misdemeanor case, 23MM3682, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Okay. Do you have any questions for the court or your attorneys or the state?
No, sir.
Okay.
That is one count of misdemeanor battery in that case.
Thank you. You're adjudicated guilty. You're sentenced to credit for time served in that case. You'll need to pay the court cost, the public defender's fee. Those amounts will go to a civil lien or judgment. Thank you, sir. Good luck to you.
Thank you.
Thank you, State. Thank you, PD, for the misdemeanor. Thank you. Well, Mr. Shoulders.
Yes, Judge. This will be a change of plea this morning. It'll be a plea of no contest, and it'll be adjudicated guilty. It'll be 6 months in the county jail, Judge, followed by 24 months of drug offender probation, where there'll be a curfew from 7 p.m. to 7 a.m., substance abuse evaluation, and any recommended treatment. There's random urinalysis, no trespass at prime storage, cost investigation of $146.51 to Niceville PD. There's a VOP cost prosecution of $100, court cost of $615, defense cost of $250, and there's the $40 per month of the supervision, Judge. If I may approach with the...
Please. Thank you. Mr. Shoulders, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Shoulders, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Have you signed the plea agreement?
Judge, I apologize. May I make a correction on that, please?
Sure. Mr. Shoulders, have you ever been adjudicated guilty of a felony before?
I believe so, sir.
Okay.
If I just have 3 minutes, Judge. correct. That was with Ms. Davis. Judge, I'll just make a correction. This was a counteroffer that was accepted by Ms. Davis. It was 90 days in the county jail, Judge.
Not 6 months.
Correct. It was a counteroffer that was accepted. I apologize. So back to that 90 days we talked about. Yeah.
This is both cases, correct?
Correct.
Yes.
Thank you, Judge.
Yes, sir. Mr. Shoulders, that certainly is better. I'm glad that Mr. Koch stated that. Certainly hate to sentence you to more than you agreed to. Mr. Shoulders, did you sign the plea agreement?
I did, sir.
Okay. Do you have any questions for the court or Mr. Koch or the state?
No, sir.
Mr. Shoulders, I do accept your plea. You're adjudicated guilty. You're sentenced to 90 days in the Okaloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time between your cases and counts. That's followed by 24 months of drug offender probation. You'll have a 7 p.m. to 7 a.m. curfew. You'll need to submit to a substance abuse evaluation within 30 days after your release from the jail. Begin any treatment, if it's recommended, within 60 days after your release from the jail. Submit to random urinalysis. Have no trespassing at prime storage. You'll need to pay the cost of investigation of $146.51, the $250 public defender's fee. The other court costs are imposed for the new case, $100 cost of prosecution. Thank you, Mr. Shoulders. Good luck to you, sir. Yes, ma'am. Prior supervision. Thank you, ma'am. Best of luck.
Glenn Shelby?
Thanks for that.
Any questions? Okay.
Hello, Mr. Shelley.
Good morning.
Good morning, sir.
If I just may have a moment, Judge, just to
Certainly.
the autograph. And then 1019.
What,
1019, yep.
Are you going to do Brooks? Sir, do you want me to tell court security to tell them the way
Yes, Your Honor. This would be a change of plea this morning. It would be an admission, and we're here in 2021 CF 1454. Adjudicated guilty. If you revoke and terminate, it would be 7 months in the county jail, $100 for the cost of prosecution, and $150 for defense costs. And I'm just going to hand this to the state for.
Thank you. Mr. Shelley, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Shelley, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Please. Thank you. Thank you, sir. Mr. Shelley, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 7 months in the Okaloosa County Jail with credit for all time served. You need to pay the $100 cost of prosecution, $150 public defender's fee, all of the outstanding financials. Well, let me ask you this. Do you want some period of time to pay the outstanding financials after you get out of jail, or do you want them to go directly to a civil lien or judgment? Take a second and talk to Mr. Couch about that.
The set at 50,000. He's asking for something lower than that. It's a trafficking case, methamphetamine. It's in the car. He's unresponsive to make contact. It's 14.7.
Judge, could we get, just say 4 or 6 months when he gets released?
Yes, sir. So, Mr. Shelley, the outstanding financials will go to a civil lien or judgment 6 months after you're released from jail if you fail to pay them.
Yes, sir.
Okay. Thank you, sir. Good luck to you.
Okay, thank you.
Okay.
Thank you.
At $1,000 in one case and $1,500 in the other, both cash and professional. We're just asking you to verify the signature.
What's his history?
Hello, Mr. Villa. Good morning, sir.
Hardly any at all, from what he tells me.
Mr. Villa, I read your your motion, and here's what it says. It says that you've been in jail since September 27th. The present bail is $50,000. That you were employed with Sonic for 8 months, lived in the area for 5 years. It says you graduated from high school, or at least have that amount of education.
Yes, sir.
Yes, sir, Mr. McKinney?
Judge, may I take some brief testimony from Mr. Villa?
Mr. Villa, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir.
Sir, I put 543 Sullivan Street in Port Walton Beach. Would that be your address if you were to make bond?
Yes, sir.
Who lives at that address?
My girlfriend of 20 years,
And what is her name?
Angela Morales.
If you were released on bond, would you be able to get your job back at Sonic?
Yes, sir.
So you would be able to go back to work?
Yes.
If you were to be required to do any pretrial services by the court, is that something that you would be agreeable to do?
Absolutely.
I have no further questions for Mr. Villa.
To the state?
No questions for Mr. Villa, Your Honor.
Thank you. Mr. McKinney, argument?
Judge, this was set as a $50,000 cash professional bond for a trafficking of methamphetamine, 14 grams or over. The report says 14.7 grams. That's obviously not FDLE weight. That's something that I'm going off of the arrest report.
Yes, sir.
Count 2, which is a possession of paraphernalia, which is ROR. So we're asking the court to reduce the $50,000 amount to a lower cash or professional amount for Mr. Villa so that he may be able to make bond. And if the court is inclined to lower the bond amount but make Mr. Villa comply with pretrial services, he would certainly be in agreement to do that.
Okay. Thank you. To the state?
Your Honor, the state has no objection, and I apologize, I'm filling in for Ms. Davis right now. The state would have an objection to a signature bond or something of that ilk, but the state would have no objection to a $25,000 cash or professional bond and pretrial services with random year analysis.
Okay. Mr. Villa, when I was doing my homework, you know, I had different thoughts about the motion. What the state is stipulating to is less than what I was thinking about. So your motion for bond reduction is granted in part. Your bond is reduced to $25,000 cash or professional with pretrial services. You'll need to submit to a random year analysis. When will I see Mr. Villa again? Will it be November 13th?
Judge, he has an arraignment date
On November 16th.
on November 16th. So the court will see
No
him again then.
information's been entered?
No information has been filed, Judge.
So the arraignment date is when?
November 16th
Okay.
at 1:30.
Okay. Mr. Villa, I'll see you no later than then.
Thank you, sir.
Thank you, sir. Thank you.
$1,000, $1,500. It's an illegal dumping and hydrocodone in his pocket.
Good morning, Mr. Vick. Mr. Vick, so I read your motion, and it states that you've been in jail since September 11th of this year, that the current bond is $1,000, that you received SSI and SSD in the amount of $964 a month. You've lived in the area for 40 years, that you're single. It also says that you reside in Niceville, and I had a note when I did my homework, then I said, or homeless, or with who? So those were questions that I had. Mr. McKinney?
Judge, may I take some testimony from Mr. Vick?
Sure. Mr. Vick, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Mr. Vick, I placed in my motion to the court that you make $964 a month, and that's disability or SSI, is that correct?
Both.
Is that a combination?
Yes.
So is that how much you get a month?
Yeah.
And the address in Niceville that was provided, the 195 College, is it CV, Niceville?
Yes, sir.
Who lives at that address?
Eddie. I don't know his last name, but it's at Eddie's house.
So it would be a friend that you would be staying with
Yes,
in
sir.
Niceville? Is that something that you believe that you're welcome at that address?
Yes.
Okay. Is there anything else you want Judge Brown to know before he makes a decision on your bond amounts today?
No, sir.
Okay.
Any questions from the state?
Mr. Vick, do you know if you remain incarcerated, would you be in danger of losing your benefits?
Yeah.
That's the only question the state has.
Okay. Mr. Vick, have you stayed with Eddie before at that address?
Yeah, I stayed for a couple of days, but he also just let me move in there
Okay, when did he let you move in?
about 2 days before I got arrested.
Okay. Okay, thank you. Any questions from the attorneys based on the court's questions?
None from the state, Your Honor.
No, Judge.
Mr. McKinney?
And Judge, this is set as a $1,500 cash or professional bond in the 2082 case number and a $1,000 cash or professional bond in the 2083 case. Both are an arrest on the same day. The felony in one case is legal dumping, which I believe is going to be a campsite that I believe that Mr. Vick's brother was living at, that Mr. Vick had some items there as well. You've heard from Mr. Vick that he was trying to better his situation at that point in time. And then the 2083 is a one-count information related to hydrocodone. And then once again, that was from the arrest at the same time. And that was a Tylenol bottle that contained 2 pills that were in his left pocket. We're asking the court to convert the cash or professional bonds to signature bonds for Mr. Vick so that he can get back out into the community and is not in danger of losing his benefits.
Okay, to the state?
Your Honor, the state's only objection would be to a signature bond without pretrial services. We think, based on the hydrocodone being found, that he would need pretrial services with random urinalysis.
Okay, so you stipulate to both of the bonds being signature bonds, but appoint pretrial services with random UAs.
That would be the state's wish, Your Honor.
Okay. Mr. Vick, I do grant your motion for bond reduction. Both of your bonds are converted to signature bonds, so you'll be able to sign out of jail today. I do appoint pretrial services, so you'll need to report to them and keep in touch with them and submit to random urinalysis from them. Okay?
Where at the pre-trial thing?
It's in Crestview. They will give you a map of where you need to go when you're released.
All right.
Judge, he's also on the arraignment docket in both case numbers 2082 and 2083. We would enter pleas of not guilty, waive formal reading to the 2-count information in 2082 and to the 1-count information in 2083. Both of those should be scheduled for the 11/13 pretrial date at 9 a.m. So Mr. Vick would need to be back in court for pretrial on November 13th at 9 a.m.
Mr. Vick, I'll see you on November 13th at 9 o'clock, okay?
All right.
Okay.
Thank you, sir.
Let me know when you...
Thank you. Thank you, ma'am.
But he was out on bond.
Hello, Mr. Wedges.
Got this personal license suspended.
I'm just going to leave it in court's discretion. Mr. Wedges, on the motion for bond reduction, it says that you've been in jail since September 18th, that your present bail is $1,500, that you're self-employed, doing construction for the last 4 years, that you lived in the area for 3 years, you have 1 child, your brother lives in the area, and you've never failed to appear. Mr. McKinney?
And Judge, in reference to the failure to appear, when I was doing my homework in preparation for today, I believe that there was one issue related to a failure to appear related to a misdemeanor account. But I would ask Mr. Wages to explain that to the court if the court places him under oath.
Mr. Wages, if you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand out.
And based on what I just told Judge Brown about what we had put in our motion related to failing to appear, can you explain to the court the failure to appear?
The failure to appear was, I had an officer come and give me citations on the 26th. On the 11th, he came back to me and asked me to sign other paperwork that he forgot to give me, all right? At that same point in time, whenever he came up to me, I put my phone on record, and I put it on the hood of the truck, and I asked, told him it was, I was recording the conversation just for my personal acknowledgement, and then he proceeded to tell me, that I had court on the 16th, and it was actually, court was on the 15th.
Was that for your misdemeanor case?
Yes.
Okay.
Yes, and I was over the misdemeanor case, and so, I mean, I had not received any paperwork or anything. All the paperwork was mailed to my brother's house instead of where I had asked him to send it. So I didn't have any other choice but to, believe him,
Yes, sir.
That's fine.
Thank you.
And Judge, that is a misdemeanor case in which he is currently pro se in. That is an ongoing case. I don't believe that Mr. Wages is seeking appointment of the public defender for the misdemeanor case, but that did change based on the bond motion that the court reviewed. So we're asking the court to consider converting the $1,500 cash professional amount to a signature bond. Currently, the bond is revoked in the misdemeanor case that I know that Mr. Wages is currently proceeding pro se on.
It's already been reinstated.
Okay, it's already been reinstated?
It's already been reinstated to a $2,000 professional bond.
Okay.
So, signature bond, excuse me.
So we're asking the court to consider a signature bond given that this is a driving while license suspended case.
Okay, to the state.
Your Honor, given his history and circumstances and the commission of a new offense, the state believes that a $1,500 cash or professional bond is appropriate.
Thank you. I did see in the addendum to probable cause 3 previous driving while license suspended or revoked convictions. Mr. Wages, taking into the totality of everything that I know, respectfully, your motion for bond reduction is denied, so it will remain a $1,500 cash or professional.
Madam Clerk, has an information been filed in this case? It is also on the arraignment docket for this afternoon, Judge.
Yes, sir.
Can you see in your system if an information has been filed?
I will check on that right now. What's his first name? No, Your Honor, an information has not yet been filed in his case.
Okay, so
the issue becomes, if we say, let's go to the next available arraignment day, that's not until the 16th
Right.
of November, which
why
is
don't we
after
set
the
them both for
pretrial.
November 13th?
That's fine,
Want to do
Judge.
that?
If we could just set this case on November 13th, where it's already scheduled for pretrial.
Yes, sir. So, Mr. Wages, I'll see you November 13th at 9 o'clock, okay?
Yes, sir.
Thank you, sir.
Indeed.
Thank you. Yeah. Yes, ma'am. That'd be great, too. Thank you. Hello, Mr. Williams. Good morning.
Judge, Mr. Williams is here in 2 case numbers, 23 CF 1374 and 23 CF 1375. It's for a felony violation of probation arraignment. We'll enter a denial and ask for this to be set for a hearing without subpoenas on the next available date. Okay. But we will certainly try to resolve this matter as quickly as possible.
Okay. Mr. Williams, I'll see you no later than November 16th, but if the state offers you something that you want to accept before that date, Mr. McKinney can set a hearing to talk about that motion or that plea, possible plea. Okay. Thank you, sir.
Winning.
We've got an officer that is on Zoom. I don't know what that's
Judge,
for.
that's
Thank you,
probably for the bond hearing from Ms. Tidwell, that Ms. Davis was waiting for the officer to sign on to Zoom.
Okay.
Good, you're good to go.
Thank you. Thank you.
Judge, this is Mr. Derek Wilson before the court in 19 CF 1787.
Mr. Wilson.
Judge, this is a violation of probation. We have previously entered a denial and we're trying to seek placement. Part of his violation of probation was removal from Haven House, so we were looking at other options. to see if we could present that to the state and to the court. We have not gotten that placement lined up yet, so I would request a continuance of this hearing for another hearing to be set without subpoenas, but we are actively trying to resolve it.
Any objection from the state?
No objection from the state, Your Honor.
Mr. Wilson, do you agree to the continuance?
Yes.
Okay.
Is there any transfer?
Mr. McKinney, do you want it November 16th or December 11th?
Judge, if we could keep our hands on it and set it on the next available date.
Good. November 16th. I'll see you no later than then. Thank you, sir. Ma'am? 9 a.m. Yes, ma'am.
Judge, this is Ms. Tidwell. I believe that we were going to wait for Ms. Davis for the bond hearing.
Okay. Hello, Ms. Tidwell. Okay, we're waiting for Ms. Davis. Do we know where Ms. Davis is?
In 2B for the case.
Your Honor, she has a bond hearing in front of Judge Ketchel on a homicide case.
Okay.
And she's waiting for that to occur, and then we'll come back down here. I will inquire with her if this is anything that I can handle.
Okay. So, Ms. Tidwell, I'll see you as soon as I've got the right prosecutor, okay?
Yes, sir.
Thank you, ma'am.
Thank you.
Okay. Anybody else on the morning docket?
We have Tremaine Lewis, but it's with Mr. Cobb.
Right. Have we heard anything from Mr. Cobb?
Also on the 130 docket, but I don't know if the legal appearance.
Okay, so I'll ask my office to get in touch with Mr. Cobb regarding Lewis. Do you have the inmates for 1:30? Do we want?
Moving them over now,
Okay. Okay, so a 10-minute recess, is that enough? Okay, we're in recess for 10 minutes. Thank you.
all right, please.
Yeah.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Core Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
far as the 1:30?
Judge, we have Ms. Tidwell, and I have Special Investigator Crockett appearing by Zoom for the bond hearing on Ms. Tidwell.
What do you want to do with Mr. Cobb's not present?
Capious? Right.
Is it my understanding he's on the docket for this afternoon, Mr. Cobb's?
So, my understanding is this is just VOPs, and Mr. Lewis has a new law violation. So our thought process had been that these VOPs would likely just need to track with the new law violation. Mr. Cobb just may not have awareness of today's court date because he was just recently appointed to these cases.
Okay. So, does Mr. Lewis have a hearing this afternoon, or it's just Mr. Cobb on another defendant?
Has he filed a written not guilty in the afternoon case?
So, as far as the officer, if we just continue these hearings until this afternoon, do we need the officer?
No, for Tidwell's bond hearing. Teresa Tidwell.
Oh, okay, I'm sorry. Strike that. Okay, on Cobb, on Lewis, thank you. We'll just continue the Lewis hearings until this afternoon at 1:30. Okay, now on Tidwell, I'm sorry.
Judge, this is Ms. Tidwell before the court in two case numbers, 19 CF 2521 and 19 CF 2519. I'd like to take some testimony from Ms. Tidwell to fill in some information for the court.
Yes, sir. Let me get my notes. Ms. Tidwell, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, ma'am. You can put your hand down. Thank you.
Ma'am, could you please state your name for the record?
Teresa Tidwell.
And when were you placed on probation in these 19 CF cases?
December 4th, 2019.
Was one of the conditions that you pay restitution?
Yes, sir, there was, and there was some confusion with that.
If you were out on bond right now, would you have employment?
Yes, I would. Yes, sir.
What would you be doing?
I am a personal injury paralegal. I've been a paralegal for 35 years.
And is it based off of that work they would be using to pay the restitution?
Yes, sir, that is correct.
Who do you normally work with?
Ben Roberts out of San Diego, California, and also Mike Warda, and he's in Charlotte, California. And we have several other offices, and I am the senior paralegal for these firms in California.
The part of the allegations on the violation are charges in Alabama.
That is correct.
Have you been to any of the court dates in Alabama?
No, sir, I have not.
Is it your desire to make bonds so you can go to the hearings in Alabama related to that charge?
Yes, sir, it is. I'm not a convicted felon, and I do not want to be. Justice is what I strive for the victims that our firm represents, and I would like to continue to do that.
If you were released, where would you be living?
My same residence I've lived at for over 3 years, at 294 Lee Road, 849 in Auburn. Well, Opelika, it's the Auburn area. Sorry.
Is there anything else you want Judge Brown to know before he makes a decision?
I'd like to talk about what's going on in Alabama and why, but I don't know if we should because it's
given that this is televised, recorded on the record, however you want to call it, then I don't want to get into specific facts related to the Alabama offense, which is a new law offense that's charged in Alabama.
Right. I would like to add, sir, if I may, I completed 3 years of supervised probation, and at the time, my probation officer in Lee County that was monitored for Okaloosa did not know, nor did I, that my probation officer had violated me 2 weeks before the date that I had completed that probation. The day that I was supposed to report, she called me and told me I was done, but I needed to take care of the restitution.
That was for the original violation related to just the restitution,
That is correct.
and then an additional violation count was added for the new law offense in Alabama. Is that
In
correct?
June of this year. Yes, sir.
When were you arrested for this violation of probation?
June the 1st, 2023. I had no idea I had a warrant at all.
And you've been continuously incarcerated since June
Yes, sir.
of 2023?
Yes, sir, I have.
Have we been able to review any of the documentation related to the Alabama offense?
None whatsoever.
No further questions from Ms. Tidwell.
Okay, to the state, questions?
So, Ms. Tidwell, you were working as a paralegal when you forged Mr. Wemort's name on documents for his law firm and had those false checks?
I was working for him.
And you've pled to that fraudulent activity, is that correct?
With the charges adjudicated.
And you have a current balance for your restitution of over $12,000, is that right?
That is correct.
But you've been working as a senior paralegal this whole time.
Yes, that is correct, but not.
So you haven't paid your restitution even though you have been working the entire time that you were on supervision?
I paid over $3,000. There was confusion with the payment of that.
Sure. I don't have any other questions.
Okay. Mr. McKinney, redirect.
No, Your Honor.
Okay. Argument, Mr. McKinney, or evidence from the state?
Judge, I have the Senior Investigator Crockett that's appearing by Zoom.
Mr. Crockett, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Let me start my camera. I'm sorry. Yes, sir. Yes, ma'am. Ms. Davis?
Ms. Senior Crockett, can you hear me?
Yes, I can. Can you hear me?
Yes, sir.
Okay.
Ms. Senior Crockett, can you explain what your job is? Can you tell the court what your job is?
What the charges is?
I don't know which one's going
Where's
to be
the
the
mic
easiest.
for that? Okay. We're trying to get a microphone closer to the state. Okay, now try it.
Would it be helpful?
Can you hear me better?
Yes.
Okay. Ms. Crockett, can you tell me what your job title is?
My job title is I'm a special agent, state law enforcement for the Alabama Department of Insurance. I'm currently assigned to the Insurance Fraud Bureau.
And you were assigned to work on a case involving Ms. Teresa Tidwell, is that correct?
Yes, ma'am.
Can you give the court some background on that case?
I got involved with the case when Ms. Tidwell made a complaint to Protective Life Insurance about Deanne Prestridge committing insurance fraud. Excuse me.
And through your course of investigation, did you locate some incriminating evidence against Ms. Tidwell?
Yes, ma'am. She gave me, after I subpoenaed the documents and recordings from Ms. Tidwell, between Ms. Tidwell and Ms. Prestridge, she gave me all the documentation that she had kept. And in that documentation, it was clear that she was involved in the insurance fraud along with Deanne Prestridge.
Can you explain to the court exactly what the situation was in this case?
Deanne Prestridge is on video changing for her husband or her husband, I put it that way, or his $200,000 life insurance policy, changing the beneficiary over to her from his mother Prestridge. Husband, a Timothy Anderson.
And how was, in your investigation, how was Ms. Tidwell involved in the actual crime to that?
Ms. Tidwell married the Timothy Anderson and Deanne Prestridge Anderson over Zoom. Then, in the documentation that I was provided by Ms. Tidwell, the marriage appears to be not valid because Ms. Tidwell, Ms. Anderson, Prestridge Anderson, actually says that she will forward his signature on the documents, the change of beneficiary, like she did the marriage certificate. And on the marriage certificate, Ms. Tidwell also signed that it was a legal marriage. The marriage, or pardon me, the documentation that I received back from Secret Service saying that Timothy Anderson did not sign the document for the marriage certificate.
And how do you know, through your investigation, that Ms. Tidwell is not an innocent, just happened to be a third-party notary that just happened to get involved in this? Just for the record, Mr. Crockett, or Investigator Crockett, we don't have the benefit of the videos for today's bond hearing.
Okay.
And Judge, for the record, if I may.
Yes, sir.
The defense has been provided no information at all related to the Alabama charge whatsoever. No reports, no video, nothing at all. So everything that we're hearing in court here today is something that we're hearing for the first time.
It's in the VOP, Judge. It's in the report in the VOP.
Understand. Okay. Thank you.
Investigator Crockett, I'm sorry, I cut you off. How do you know that Ms. Tidwell was not an innocent in this fraud by Ms. Deanne?
The text messages between the two clearly are, it's clear that they were both involved in the insurance fraud, and between the two. They actually talk about what they're going to do, where they're going to go after Mr. Anderson's death. And I'm trying to talk because there's so much information. Sorry.
What would we see in the videos?
The videos, one of them starts out with Deanne Prestridge Anderson. She shows her, and then she says he's alert, he's ready to sign the benefits, or sign the benefits over, the beneficiary over, and then it shows Mr. Anderson. He's got a trait in his inn. He is barely awake, almost comatose. He wakes up, and you can tell he's not able to sign or even comprehend what's going on. And a short time later, Deanne comes back and says she did it, and Ms. Tidwell said, "Did what?" And at that time, she said, "I signed it," or he signed it. And from there, the video, she actually says, "You're going to delete this video, aren't you?" And the second video we have is Mr. Anderson, once again, laying in the hospital bed. He's got a trach-in. He's a lot alert, per se, but he's nonverbal. The video shows him with some type of paperwork in his hand, and then documents, and then the video is off.
And in both of these videos, what is Ms. Tidwell's reaction on the other side of that video?
She is, the first video, it's kind of broad language to actually saying for.
It's, Mr. Investigator Crockett, I'd rather you be accurate than dancing around the issue.
Ma'am?
I'd rather you be accurate than dancing around the issue. You can go ahead and say it.
Okay. She actually says, "Wake up, motherfucker." She continuously asks him to wake up, then says, "This is just in case." Well, the other video is, "Just in case I kill your wife, this is your last will." So.
Judge, I don't have any other questions at this time. Just to be clear, I have the videos and the paperwork on an extensive jump drive. I've been in touch with Mr. McKinney's office trying to get this disclosed to them in a way. I have the videos copied that I had intended to play. I have them on a disc currently. I wasn't going to play them at this point since they have not been disclosed to Mr. McKinney. If Your Honor would like to see the videos, we can continue the hearing to another day when I can make sure that these are disclosed to Mr. McKinney. I didn't want to put him at a disadvantage today.
Mr. McKinney, cross.
Investigator, can you hear me, sir?
Yes, sir.
So this action in Alabama was initiated by a complaint by Ms. Tidwell?
Yes, sir.
And a lot of the documentation that you're referencing was provided by Ms. Tidwell?
Yes, sir.
And and I'm at a disadvantage related to some of the paperwork here, but were there any other notaries involved?
There was one notary in Birmingham that Ms. Tidwell provided. When I spoke to that notary, she had no knowledge of the actual crime or anything of that nature.
So in your investigation, is there a July 22nd event related to a notary that's other than Ms. Tidwell?
Yes, sir. I believe that's the date. I'd have to look and see.
Were there any directions by any probate judges related to any of this paperwork?
The probate judge, Judge Story, had all of the documentation sitting on his desk when I talked to him.
No further questions.
Investigator Crockett, do you have any objections to Ms. Tidwell receiving a bond on this VOP?
Pardon me?
Do you have objections to Ms. Tidwell receiving a bond on this violation of probation?
Well, if she's bonded down in Florida, she's going to be able to bond down in Alabama. Her bond in Alabama will be $12,500. We've got a case of the other charge is practicing law without a license, or unauthorized practice of law in Alabama. So if she's working with attorneys or for attorneys, that's, I don't know how that works with her being on bond.
No other questions, Judge.
Thank you. Judge, may I ask one more question?
Yes, sir.
Investigator, are Ms. Tidwell's cases in Alabama going to progress without her there?
Yes, sir.
Do you know if there's any intentions to transport Ms. Tidwell to any of the court hearings in Alabama?
I have no idea about that.
Okay. No further questions.
Any other questions for Investigator Crockett?
No, Judge, not at this time.
Thank you. May Mr. Crockett be released?
Yes, Judge.
Investigator Crockett, you can leave if you wish to, or you can certainly still watch. Thank you, sir.
Judge Probation also has a statement from PO Michaela Shelton. She is the supervising probation officer for the state of Florida for Ms. Tidwell.
Okay. Yes, ma'am.
Shelton stated that she's absolutely against a bond. Her new law violations in Alabama are very serious. She will get a bond once she goes back to Alabama. Alabama has closed interest in her case, and she does not feel that she should be in Alabama with no supervision based upon her new charges. She should remain in jail on a no-bond BOP.
Thank you.
Judge, is there a way for me to cross Ms. Shelton, who's not here?
Not a bit. Yes, sir. Understand.
Judge, there's currently no bond set for Ms. Tidwell. We're asking this court to use its discretion to set a bond. When we first started talking, before we got into Alabama stuff, we started talking about restitution. Ms. Tidwell's certainly not going to be able to move forward and pay any of the restitution with her incarcerated here. We're asking for her to get a bond here, understanding that she has these charges, which the court has heard about in Alabama, which she intends to fight. If she posts bond here, then she will have to go to Alabama. She will have to post bond there, but that's the Alabama case. That's not something for us to really look at. So in an effort to try to move that case forward as well, that's part of our request in asking for a bond. Because she will, my opinion, and I'm not an Alabama attorney, I haven't been up there, is I don't believe that there's been anything filed to transport her to any of the court dates in Alabama. So I'm afraid that we're going to be trying this BOP down here and trying this new law offense without the benefit of her being able to even start her case in Alabama.
Understand. To the state?
Judge, I've been in touch with Alabama. They have no problem with her getting tried and sentenced for the BOP here before transporting her to Alabama to face those charges. That's not a concern whatsoever as far as Alabama goes. Now, she has not attended court dates because she was not formally indicted, because in Alabama, they formally indict on everything. So she was not formally indicted until after she was arrested and transported here for the violation of probation. So that's why Ms. Tidwell's statements saying that she had not attended those court dates, that is accurate, Judge. Now, as far as the bond on the violation of probation, she is not entitled to a bond on the violation of probation. The state is very much against any bond on Ms. Tidwell's case. The allegations are very serious. We will have the benefit of those allegations because we're going to be trying it in the violation of probation here. The concern for the state is that Ms. Tidwell is on probation for very similar charges, and she never cared about the restitution the whole time she was on probation. So coming here today and saying that, well, she needs out to pay the restitution, that's just disingenuous at this point. Now, as far as the charges in Alabama, I think we have sufficient information at this point that we are going to proceed forward with the violation of probation hearing soon on that case. The similarity that she was working for an attorney, embezzled money here, now she's there working for an attorney, still doing things to steal money. Those similarities in the crime is the concern for the state at this point, and we ask that she remain with no bond.
Okay, thank you. Mr. McKinney, you get the last word at your motion.
Judge, she's been in jail since June. We've been provided no information at all related to what we've heard about here in court. Yes, it's in the violation report, but that's one paragraph. So if we're going to be trying this whole thing as effectively trying the new law here in Florida for Alabama, she has an evidentiary scheduled for December. I don't think that's a real quick turnaround for Ms. Tidwell, given that she's the one sitting in jail.
Okay, thank you. Tidwell, I was just looking at the paperwork. I had printed off an older violation report, and so I was looking at that when I did my homework, so I wanted to make sure that I was up to speed.
If he looks at it, he sees it.
When I was doing my homework, and then again I see in the violation report has amended violation report dated 10/26/22, but yet at the top it says date June 21st, 2023. And in that it speaks about domestic violence.
Judge, that was a violation which was dismissed. That case was dismissed.
Okay.
So I don't
Thank
believe it's part of this violation of probation.
Good. Thank you, sir. That clears it up. Let me throw that away. Because that addendum was filed on June 21st of 23. And then there was an amended affidavit for violation of probation filed that same day. Traditionally, those go hand in hand, but there are a lot of different things in the affidavit that aren't in the report, I believe. Okay, thank you. Miss,
Line 88, that's the newest deal, the addendum deal.
I'm sorry.
Line 88 on the clerk's computer? 621.
Yes, ma'am. Right, that's the one that I pulled up, but then docket entry 87 is the addendum to violation report.
Those violations start at the end of page 2 on the
Additional
621
violations.
addendum.
Got it. Yes, ma'am. Okay, thank you. So they are in there. Good, thank you. Ms. Tidwell, based upon what I know at this point, respectfully, your motion for bond is denied, so you'll continue to be held without bond. So when are we going to schedule the evidentiary hearing?
It's scheduled for December 11th at, is it 1:30?
At 1:30, yes, ma'am. So Ms. Tidwell, I'll see you then. Mr. McKinney, if you don't think you can get up to speed, I mean, let us know sooner than later, a motion for continuance of that.
Yes, sir. And I will endeavor to get up to speed as quickly as possible, but that's going to be
Understand.
predicated upon getting the information from the state.
Right, yes, sir. Okay, thank you, Ms. Tidwell. Okay, yes, ma'am.
Your Honor had scheduled her for a November court date, but she did get everything paid. She went down to the clerk's site and got everything paid off. That she was pro se.
Good, yes.
As a friend of the court, she has brought back a receipt showing that she's paid everything.
Has the state seen that?
Yes, Judge. At this time, we would ask to dismiss the violation of probation and successfully terminate Ms. Vaughn from supervision.
Great. Your supervision is terminated.
Thank you.
Thank you, ma'am. Thanks so much for coming back up.
Thank you, sir.
Judge, I need to run back to Judge Ketchell's court. I have a copy of the letter and some of the attachments that I was going to talk about this afternoon on
Yes,
Mr.
ma'am.
Taylor's case.
Thank you.
Judge, this is Lisa Walker.
Thank you. Hello, Ms. Walker. Thank you. Yes, ma'am. Mr. McKinney?
Judge, Ms. Walker is on the 1:30 arraignment docket, and we will acknowledge the receipt of a 2-count information, waive its formal reading, and enter a plea of not guilty. My understanding is that this case is being transferred to Crestview because she has pending cases in Crestview. Is that, I believe Ms. Davis just walked out.
Okay.
That is my understanding.
Okay, so has it been,
I've had communications with the
Transferred
state
to
related to
Crestview?
transfer. I don't think anything's been filed when I looked this morning.
So do we need to go ahead and set it for my court until that's transferred?
Yes, sir.
So it's a new case, so November 13th at 9 o'clock. If you remain in my division, I'll see you on November 13th, okay, Ms. Walker?
Okay.
Thank you, ma'am.
Thank you. Next we'll do Jillian Watson.
Thank you.
Judge, this is Jillian Nicole Watson before the court. She's here in 22 CF 1880. The state has filed a one-count information. I tried to negotiate with the state. There was an offer made, but there have been some failures to appear since the time of that offer being made. So I've been unable to confirm what the state's offer is at this point. So I'm going to enter a not guilty plea, waive formal reading of a one-count information, 22 CF 1880. That would schedule Ms. Watson's next court date for the November 13th court appearance at 9 a.m.
So, Ms. Watson, that means I'll see you I'll see you no later than November 13th. But if the state offers you something that you want to accept before that, and I hope that they do, then Mr. McKinney can set you for a hearing before then, okay? Thank you, ma'am.
Judge, could we bring her back at 1:30? I believe that I may be able to get an answer by then.
Okay, sure. Ms. Watson, I'll see you this afternoon.
Can we hold her to 1:30? I'll take it. I'll see you at 1:30.
Thank you.
Judge, if I just have a brief moment.
Yes, sir.
Yep. Yes, Judge. Thomas Cott's filling in for Attorney Scott Kleins. Now, on my end, I haven't received any paperwork about a possible null pros. I know his notes indicated that they did talk to the victim, but I don't know if that went through.
To the state, any offer to Mr. Mose? Or better than that, are you expecting the null process?
We're not expecting to null process at this time, Your Honor.
Okay, and no offer to Mr. Mose that you're aware of?
I apologize, Your Honor, we're paperless, so let me go in and check the offer. Your Honor, I don't think there's been an offer made at this time.
Okay.
But I believe Mr. Moose has another open case.
And when is that set?
It's set for 11:30 for trial.
Okay, so Mr. Mose, I'll see you on both of your cases on November 13th. Okay?
Thank you, Judge.
Thank you.
Judge. Yep.
Thank you. Mr. Payton's case is 23 CF 2054. Hello, Mr. Payton.
Hello, how you doing?
Doing well. How are you?
Good. How about yourself?
Mr. Payton, you're charged with drug trafficking and fentanyl. Do you wish for me to appoint the public defender if you qualify financially?
I'm going to get a paid attorney soon.
Okay. And did they provide you with a copy of the information? Okay, that's the charging document from the state that charges you with the drug offense. I will enter a denial for you, and we'll set it for the next pretrial conference, which is November 13th at 9 o'clock. If you're going to hire a private attorney, do it sooner than later so that they can talk to the state and get up to speed before November 13th.
Okay, sir. Is there any possible way I can ask for a speedy trial?
You can. You need to do that in writing.
Oh, in writing?
Yes, sir. Get your attorney to do a notice of appearance. If you decide you're not going to hire a private attorney, fill out the financial affidavit and see if you qualify for a public defender.
All right. Okay?
But I'll see you no later than November 13th.
Okay, thank you.
Thank you, sir.
Good morning, sir. Yes, Judge.
Yes, sir.
We'll be entering a not guilty and requesting this be set on that 11/13 pretrial, Your Honor.
Okay, there's no offer from the state for Mr. Pearson that you're aware of?
Your Honor, the offer is an adjudication of guilt, 6 months Okaloosa County Jail, court costs.
Okay.
And any restitution.
Judge?
Yes, sir.
If we can put a client on the 130, this is the first time I got this offer. I think this is up our alley. If we could just pass them and see him this afternoon.
Okay. Do you want to just step away from the microphone and ask Mr. Pearson if he has any interest in accepting that? If he says yep, then we'll bring him back this afternoon. If he says no, then I'll see him on November 13th.
Yes, thank you.
Since that 6 months, I don't know how long he's been in, but I suspect the 6 months would go until November 13th.
Yes, Judge.
Mr. Cobb is appearing on his case. Is Mr. Lewison back? Okay, if we can do him next. Thank you.
Judge, if we could put this on 11/13.
Okay.
Pre-trial, please.
Yes, sir. So, Mr. Pearson, I'll see you back here on November 13th, okay?
Okay.
Thank you, sir. Mr. Cobb, I think you were appointed late to this case, and that's probably why you weren't on notice of it?
Yes, I'm actually on notice of it, but I wrote a report yesterday, trying to have a PPR trial this morning, and I told your DA that as soon as I got a break from the PPR trial,
Mr. Cobb, you did, and I saw that email, and you're exactly right. I'll be asking for a continuance. At the first break I get, I'll appear. Good.
Yes, sir.
Thank you, sir. Let's get your client out here.
Yes, sir.
And I apologize, Mr. Cobb, I had that in my file, on the top of my file, and I didn't read it, and I apologize. That was my fault.
Oh, I feel a bit better now.
Yes, sir. Totally my fault. Mr. Lewis, if you'll come to the lectern. Good. Mr. Lewis, your attorney, Mr. Cobb, is on the Zoom. You can see him on that screen.
How you doing, sir?
Mr. Cobb?
Yes, Judge, this is Mr. Lewis. The court appointed me to represent him, and I played 4 cases. new law violation, the 2023 case, but the rest of them are real cases from 2015 and 22, I believe. I don't have a case number right here with me, I know there's 4 of them, and we're here today on the DOT cases.
Yes, sir. Is the new case, is it set for November 13th? Arraignment this afternoon. Do you wish to waive, do you wish to enter a plea on the arraignment on the new case, Mr. Cobb?
Yes, sir. I was going to enter not guilty plea on the new case and not with regards to the DOTs. And I was just going to ask for a one-cycle continuance to the next court date in November, so I can have an opportunity to go talk to Mr. Lewis and then also talk to the state about a possible resolution to the case or where we are.
Okay, so you don't want the pretrial on November 13th, or you do?
Oh, I do want that, yes, sir.
Okay. So, Mr. Lewis, I'll see you on all of your cases on November 13th.
Okay, thank you, sir. Is there any way that I could, someone can write that on this piece of paper for me? Oh, it is? Okay, thank you so much.
Thank you, sir. Thank you, Mr. Cobb.
Thank you, sir.
Sorry for the wasted anxiety. I always wanted to have a yacht and name it Wasted Anxiety. So,
Thank you, Mr.
Thank you,
Cobb.
sir.
Have a good rest of the day.
You too.
Is that it? Thank you, sir.
Yes, sir. Thank you.
Christopher Russell.
Yes, Judge. May I have just a brief moment?
Sir.
Thank you, Judge. We'll be entering a not guilty this morning and waiving formal reading of the charges, Your Honor.
Okay. So, Mr. Russell, I'll see you back here no later than November 13th. Okay? Thank you, sir.
Rodney Swain.
Thank you. Hello, Mr. Swain. Good. How are you?
Judge, can I just have a brief
Certainly.
moment? Thank you, Judge. We will be entering not guilty and waiving formal reading. My client does have another charge in a case in front of you that's also set for the 11/13, if we can keep them together at the same date.
Mr. Swain, I'll see you on both of your cases on November 13th.
Yes, sir.
Thank you, sir. Thank you. Hello, Mr. Watts. Good morning.
Judge, we're going to acknowledge the receipt of a 6-count information, waive its formal reading, enter a plea of not guilty. This is scheduled for November 13th for pretrial.
Okay. Mr. Watt, I'll see you back here on November 13th. Thank you.
We'll take a copy of this.
Okay. Anything else for this morning? Okay, so we're in recess until 1:30. Thank you.